Welcome to Immigration Quicktake. This is Ellie Rutledge with the American Immigration Lawyers Association. Last week, a U.S. district judge enjoined the federal government from detaining Central American mothers and children for the purpose of deterring future immigration. Here to discuss the judge's decision is Melissa Crow, Legal Director for the American Immigration Council. Melissa, thanks for joining me. Can you provide some background on this case?
So the plaintiffs in this case are mothers and children who have fled violence and other types of persecution in Central America and have been detained in facilities in the U.S. since June of 2014. All of them have been deemed to have a credible fear of persecution if they're forced to go back to their countries, and a credible fear really means a significant possibility that they would be persecuted if forced to return. These individuals have been detained, the plaintiffs allege, because the government was trying to send a signal to other potential migrants from Central America not to come to the United States. And the plaintiffs allege that this policy of the government violates the Constitution, the Immigration and Nationality Act, and related regulations.
Thanks, Melissa. What did the judge's decision say?
The decision put a halt to the Obama administration's policy of detention as deterrence, and also held that in future bond decisions, the government cannot consider deterrence of future migration as a factor. So in the future, bond determinations will have to be individualized and based on whether someone poses a threat to national security or whether that individual is at risk of absconding and not showing up for a future hearing date if released.
What does this mean going forward?
I think there's still a lot of strategizing going on the ground, but my presumption is that a lot of new bond motions will be filed, and hopefully there will be better results this time around because the government will no longer be able to use detention as a tactic of deterrence. It's possible that the plaintiffs' lawyers or the plaintiffs themselves may approach ICE in addition to approaching immigration judges with their motions for a new bond hearing. But I guess we'll have to wait and see.
Thanks, Melissa, for joining me. For the rest of you, please stay tuned for more updates from the American Immigration Lawyers Association.